Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth.
For once in my life, Hank Brennan and I completely agree.
God save the Commonwealth of Massachusetts.
Welcome, welcome, welcome. This is the I Don't Belong Here show, and I am your host, Samantha Benigno. I am a behavioral scientist, a career psychotherapist, a sixth-year PhD candidate in clinical psychology, a master's level psychologist and counselor. And today, we return to Canton, Massachusetts to seek justice for Boston police officer John O'Keefe. Boy, is this case the case that just keeps on giving, as once again, the Commonwealth of Massachusetts looks to try to indict, you guessed it, Karen Read.
During the trial, jurors heard expert witnesses testify about data taken from the car's computers.
There's actually many. Depending on the vehicle, there could be hundreds.
And investigators say they had to damage the Lexus to extract the airbag and infotainment system data.
2 photographs during the disassembly process of taking that module apart.
The owner here at the shop hopes to have his work done within a week.
Well, it's going to cost her nothing. It's probably going to cost me a couple $1,000s, but I'm more than happy to do it.
One of Reed's lawyers says the defendant, who was only convicted of drunk driving, is relieved to get some of her property back.
I think very thrilled and excited to just have one more piece put to rest.
But Reed is still missing 2 cell phones. Her lawyer says they're not being returned because the Norfolk County DA is investigating her for intimidating witnesses in the case. Steve Buzang says the DA brought the case before a grand jury but failed to get an indictment. He believes prosecutors are planning to try with a different grand jury.
The facts are not there. So I don't know why they want to go back. I'm not sure. But we'll fight it out in court.
And as I have been digging through these receipts, these trial receipts, and most people have been focused on the egregious $1.4 million and counting price tag.
Second Karen Read trial is being dubbed the most expensive OUI prosecution in Massachusetts history.
Well, Priscilla, it's clear Norfolk District Attorney Michael Morrissey put his chips on the table and decided to go all in. When looking at just the cost of the expert witnesses hired by the Commonwealth, the second trial was nearly 20 times more expensive compared to the first.
That the Commonwealth spent on Karen Read's OUI, I have been busy digging through the Aperture receipts, and because of Aperture's propensity for keeping pretty detailed records, boy, do they tell a story. Today, we're going to take a look at, first, how it is that these receipts prove, number one, the Commonwealth was knowingly persecuting an innocent woman. Number two, that Aperture also was knowingly persecuting an innocent woman, and while doing so, committing perjury while under oath. And number three, how it is that we now know 100% why it is that the Commonwealth will not and cannot ever admit defeat in this case. How it is that they have to continue to put up the front that Karen Read is guilty. Otherwise, it directly indicts them. I finally understand that this case is truly about survival for the Norfolk County DA's office. And that is the reason why they just keep doubling down and doubling down. And more so than ever, what I would say to you is what I'm going to show you is so disturbing and speaks to what happens when the most incompetent, inept, outright stupid, unqualified human beings get their hand on unimaginable power and authority, and that we've got to do something about it, because people like this that are morally bankrupt and unwilling and unable to actually tell the truth, who are interested only in self-preservation, and who are fundamentally incapable of seeking justice on behalf of the people that they swear an oath to protect and serve. Now, what I am going to show you gets tedious. It'll make you want to just glaze over and stop paying attention. But I cannot stress to you enough how important it is to just listen and try to keep up, because in this case, the devil truly is in the details. Let's get started. Now, one of the real tragedies in this case is how the O'Keefe family has, from the beginning, determined that Karen Read was guilty of this crime based on the way she behaved in the first few hours after learning of John O'Keefe's death. And sadly, because of that, they have been incredibly vulnerable to manipulation, both on the part of the McAlberts, but more importantly and more tragically, on the part of the prosecution, who have played them like a violin and who have claimed that they're doing this, that this big persecution of Karen Read is on behalf of the O'Keefe family. And because of that, these people, who I think are probably very good human beings and who really do want to see justice for their loved one, have been tragically misguided. And in addition to just believing that Karen Read was acting funny the morning after John was murdered, they have also been duped by Hank Brennan, Adam Lally, Laura McLaughlin, into believing that somehow the data, the car data in this case, was an indictment on Karen Read.
To us, the prosecution put on a good case, and to us, that data from her car and from Johnny's cell phone told the whole story. From her car and from Johnny's cell phone told the whole story.
And this is why I have to warn you, we're going to have to dig into really boring stuff for me to show you just how ridiculous, how silly, how misguided, and almost unbelievable it is that the Commonwealth actually tried to pull this over on all of us. Because really, they must think that we are fundamentally brain dead in order to believe what they were trying to put forth. It was 100% smoke and mirrors, and almost unimaginably, like, it's unimaginable that the theory that the Commonwealth took and ran with and then sold or tried to sell to all of us was put forth originally by this guy.
Degrees in the scientific discipline of physics?
I do not.
Hold any degrees in the scientific discipline of biomechanics?
No.
How about in engineering?
No.
How about in kinematics?
No.
What's the highest degree that you do hold, sir?
I have an associate's degree.
In what?
Administration of justice.
You mentioned kinematics on Friday. Do you hold any certificates in the specific area of kinematics?
Yes, it's covered in the basic crash investigation classes.
Okay, so you took a class, in other words, correct?
At multiple classes.
They introduced the idea of what kinematics is, right?
Correct.
You testified about that on Friday.
Yes.
Define kinematics, if it's yours.
It deals with the aspect of motion.
It's a subfield of what broader field?
Kinematics.
Kinematics is a subfield of what broader discipline of science?
I'm not sure.
Big physics, correct?
Yes.
And it describes how points and objects and systems of objects, how they move, and how the rate they move and the rate of their velocity, correct?
It deals with the motions.
What's that called? The rate of velocity. What's another word for that?
The rate of velocity?
Correct.
I mean, it deals with the motion. It deals with forward and also deals with speed. It deals with travel and speed.
In what way does that differentiation of 2.5 pounds or approximately 2.5 pounds, in what way does that make a difference in terms of your testing?
It doesn't, and that's part of the reason why we increase the speeds to almost 30 miles an hour to look at, again, when you're bringing that much more kinetic energy from the vehicle, that's going to overcome any mass that arm has. If it, like I said, if it's a pound difference, 2 pound difference, the momentum of that vehicle moving at 30 miles an hour versus 24 miles an hour, again, kinetic energy is equal to 1/2 times the mass times the velocity squared. So even if you go up a few miles per hour, you're exponentially increasing that amount of kinetic energy from the vehicle. As you saw throughout the PowerPoint, when that vehicle is coming in at 24 miles an hour, 29 miles an hour, at those speeds, that arm, when it makes contact, is going to get accelerated up to that velocity. It's just going to reach that common velocity. It's not going to, you're not going to somehow affect the vehicle speed due to that, the fact that the arm weighing 10 pounds roughly, and you've got 6,000 pounds. It's not going to somehow scrub off speed of the vehicle.
Now, after the first Karen Reed trial ended in a mistrial, Michael Morrissey and the DA's office of Norfolk County doubled down. They put all their money, all of the taxpayer money, to the tune of well over, in the end, $1.4 million into trying to convict Karen Reed. And one of the first moves they make, in addition to hiring a defense attorney, Hank Brennan, to come over to the prosecutor's office, was to hire the accident reconstructionist team called Aperture. Now, Aperture was a friendly face to them, and we learned from Mike Morrissey's email dump from his personal server that the reason they went with Aperture is because a former Massachusetts State Police officer, a friend to them, had sold his accident reconstructionist company to Judson Welcher. So this, they knew, would be a company that they could trust to do their bidding. Now, the first contract is signed on September 10th by Judson Welcher for $75,000. And Aperture gets right to work. At one point, they have about 6 people working virtually around the clock. They purport themselves to be working on holidays like Christmas and New Year's Eve, right? I mean, they're just working around the clock, and they've got a whole team, as I said, upwards to 6 people working on this case at any given time. Now, in the end, the two that they pick to put forth in front of us is the owner, essentially, of Aperture, Judson Welcher, and their infotainment, quote, expert in Shannon Burgess. Now, we're going to get to them in just a minute. But during the trial, if you were watching carefully, that I'm sorry. All right. So from the beginning, Trooper Joseph Paul puts forth the idea that Karen Reed backs into John O'Keefe at 24 miles per hour for 64 approximately feet. Now, the reason that he comes to this conclusion is because I think he says at one point he had recently taken a class in telematics or car data computer systems in accident reconstruction, discovered that sometime around or in close proximity to when they began their testing on the vehicle, that they discovered there was this weird, what's called a trigger event, where the car registers unusual activity is taking place in the vehicle. Now, I'm going to let the experts in this case explain to you very briefly what exactly we're talking about so that it's clear the rest of the way.
When an event is triggered, what we end up with is some data from before the event was triggered and some data from after the event was triggered. The way it does that is it's kind of always recording, and as soon as it sees a trigger, it says, aha, and it goes and it grabs the previous 5 seconds. That number can vary, it can be more or less than 5, but for the specific trigger we're talking about, it grabs the previous 5 seconds of data, and then it keeps recording for an additional 5 seconds, and that completes its recording phase.
This is the text stream. So this is from Toyota text stream data. You can see the screens here. There's generally 2 types of files, what's called a vehicle control history and a PCS file. The text stream system was originally designed, according to Toyota, for maintenance issues. It seemed to come about around the same time Toyota was having problems with sudden accelerations or allegations of sudden accelerations. So the text stream data or vehicle control history will give you information when there's, for example, excessive acceleration or rapid shifting of the vehicles or rapid steering of the steering wheel. So the statements are that that's designed to help the maintenance people, if you come in with a problem with your vehicle, to diagnose what that problem is.
Now, these problems, when they show up in the vehicle control history, they are called trigger events. Okay? So they are text stream trigger events, events that were triggered by some unusual activity in the vehicle.
It has a lot of utility in accident reconstruction, because if you jam on the brakes before a crash, frequently the text stream data will record the crash.
So these trigger events are kept track of via key cycles. That is, every single time a new car is turned on and off, that's a key cycle. And it's through these key cycles that these trigger events are kept track of. In other words, any particular driving event, or not even driving event, but just any time that the car is turned on and turned off. The power in the car is turned on and turned off. And the problem with these key cycles is there's no inherent place and time associated with them. There's just a running clock. So the problem that the Commonwealth has is they have to try to sync up this running clock with a real clock, or some way to place the Lexus in front of 34 Fairview. And this is a very serious challenge. The way that Trooper Paul reasoned it, there was this 3-point turn. Karen Reed admits to a 3-point turn, and therefore, even though the key cycles do not add up, this must be Karen Reed driving the Lexus.
You did attempt to analyze the key cycles for the Lexus in order to determine placement of that vehicle. You just talked about that with Mr. Locker, right?
Yes.
I want to be clear for the jurors, because most people have probably never heard of key cycles. A key cycle does not have any location data associated with it whatsoever, does it?
Correct.
It just shows you when a vehicle is turned on, the ignition is on, and off. That's one cycle, correct?
No.
Tell me what I've got wrong.
Key cycle, the car doesn't have to be turned on.
Say that again.
It could go from off to run. The engine doesn't have to be started to off.
Understood. So if it turns on, well, every single ignition is a key cycle. Every time the engine turns on, that's absolutely a key cycle. Once it's turned off again, right?
That gets recorded as an ignition cycle.
Right. So a key cycle can be an ignition cycle, but it doesn't have to be an ignition cycle. It also can be just turning the sort of accessory on, right?
The key cycles turn the accessories on.
All right. But it doesn't, my question was, where we started with this conversation, is it does not have any location data on it whatsoever.
Correct.
All right.
Trooper Paul is so stupid and so unfamiliar with telematics that he doesn't quite yet understand what a key cycle means. He doesn't quite understand that a key cycle can also include an ignition cycle.
So when you drive your car, you walk out, get in the car, turn the ignition on, start to drive, get to your location, turn it off. That's one key cycle, right?
One ignition cycle.
But and I'm going to use the word key cycles because you use the word key cycles in your report. That's what we're talking about.
I'm using that because that's how the trigger was read.
That's how what?
The triggers were read on the text stream. That's how they read them, key cycles.
Right, key cycles.
Yes.
I'm going to use that phrase, key cycle.
Okay.
We're talking about the same thing. It's an ignition on, ignition off cycle.
It doesn't have to be on.
So just to be 100% clear about what's happening here is that even though Trooper Paul is making the claim that these trigger events happened while the car engine was on, he can't understand that the key cycle must include an ignition cycle. That is until Alan Jackson points it out.
So you mean the engine doesn't have to be turned on?
Correct.
Right. But if you're seeing triggering events, not trying to be tricky here, you're seeing triggering events, your car's in motion, what does that tell you? The ignition's on or off?
The ignition is on.
Right. That's what I'm getting to. But it has no location data associated with whatsoever. It could be here, it could be in Wyoming. The car wouldn't know the difference. It's not to report the difference to you, correct?
On the key cycle,
Correct.
on just the key cycle. The key cycle does not give out locations.
Say that again?
The key cycle does not give a location.
Right. So your analysis is trying to go from a known key cycle that you can figure out and then work backward from there to try to figure out where the car was on a particular ignition cycle or key cycle, correct?
I didn't use the key cycle to put it back.
Say that again?
I did not use the key cycle to place the car back in its location. The key cycles were, all I got from the key cycles is that they occurred close within proximity to the time we've had the vehicle, not basically saying that this was the location based off the key cycle.
He never stops to ask, do we have any sense of where the car has been in between 34 Fairview and when I started my testing?
You stated in your report that there were, quote, 2 triggers recorded on odometer 12629 and key cycle 1162, correct?
Yes.
These events were prior to the testing triggers on odometer readings 12665/12666 and at key cycle 1164. Is that right?
Yes.
Okay. So what we're saying, what you're saying in that report is the triggering events were at 1162, going in reverse in order. 1162 comes before 1164. They're numerical. Is that right?
Yes.
Every single key cycle just tags another number on top of it, right? There's no formula.
Correct.
After 1 comes 2, after 2 comes 3, 4, 5, 6, and then move on, right?
Yes.
So by the time you got the vehicle, there had been 1,164 key cycles on the history of that car, correct?
Correct.
All right. And you knew, and you put in your report, or you know, that the triggering events that you see under 1164, those are yours,
Yes.
right? I mean, that's your testing.
Yes.
And you were very clear that the triggers that you recorded, that you talked to Mr. Lally about, were two key cycles before that.
Yes.
Meaning ignition cycles, at least, right?
Yes, there were 2 key cycles.
Stated in your report, well, let me finish one other point. You said that the mileage difference between these 2 triggers and the triggers that occurred while testing was 36 miles. You just said that, right?
Yes.
And the key cycle difference was exactly 2 key cycles, right?
Yes.
1164, 1163, 1162. That's the triggering events, correct?
That's correct.
You also reiterated in your report in paragraph 23, 24, 26, and 29, and also in this exhibit, in your car's report that the triggers occurred at key cycle 1162, right?
Yes.
You were assisted in your car's report. I think you mentioned Trooper Zach Clark. Is that right?
Yes.
Trooper Proctor assisted to a certain degree, correct?
Yes.
Trooper Larini, Carol Larini, is that right?
Yes.
Also, Sergeant Sean Good of Canton PD assisted as well, correct?
Yes, in a sense.
You'll notice that moron Trooper Paul tries to distance himself from Sean Good from Canton PD being involved because remember, they're recused.
Did they all read the report before it was finalized?
No.
Did you have any supervisor read the report before it was finalized?
Yes.
And he agreed with the assessments in the report?
Yes.
So starting in 1164 and counting backward, before you started your testing, you know that the SUV had to be started, the ignition had to be turned over, and it was driven to the Sally Port in Canton at 5:31 p.m. from a tow truck on January 29th, correct?
I didn't know that.
You did or did not?
Did not know that.
Okay. Assuming that the car had to be started and put on a tow truck, that would be key cycle what?
I don't know how. I can't speak to the fact that that recorded a key cycle at that time.
Trooper Paul is so stupid that he just figures if the key cycles are off, it must be because the car didn't fire the key cycle. Duh.
I can't hear you.
I can't speak to the fact that it would record a key cycle at that time.
Okay. If the car was turned on and driven onto a tow truck, would that be a key cycle?
I don't know because these keys record different ways, so I can't speak to how or why it did not record on there. All I can speak to is that those are the key cycles. The odometer mileage is more what I was going after on this whole thing. So I can't speak to how or why it did not record on there. All I can speak to is that those are the key cycles. The odometer mileage is more what I was going after on this whole thing.
This is me interrupting your programming to remind you to like this video. Like the video. Yeah, so about those 36 miles. So what Trooper Paul is suggesting is that in between the key cycle 1162, when this alleged backing event happened, and when he began his testing, there were two ignition events, two drive events that would have totaled 36 miles. The only pesky problem with this idea is that if we look at where this car had been prior to when Trooper Paul begins his testing, the idea that what our eyes tell us is true simply isn't possible. In other words, if we're working our way backwards, key cycle 1163 would have to be when the car is driven off of the tow truck bed and into the Sally Port, and key cycle 1162 would have to be when the car is placed onto the tow truck in Dighton when they confiscate Karen Reed's Lexus. But in actuality, there's a driving event missing. And as far as anybody could tell, that event would have had to have been when the Massachusetts State Police had already taken custody of the vehicle. In between, when they took custody and whenever Trooper Paul began his testing. And like the moron that he is, he never stopped for a second to ask, where has this car been? He just assumed, well, who cares about the details? It's close enough. And it's pretty despicable, and it says a lot about Aperture, that after spending months digging through all of the evidence in this case, that they were willing to embarrass themselves by adopting Trooper Paul's theory as their own. I have to tell you that as a scientist, with all that I have being my reputation, I don't care how much money you were going to pay me. You could throw millions of dollars at me, and I would never, ever get on the stand in a courtroom and defy my science principles, the very core of who I am, and the very principles that I stand for as a human being. I would never defy them so that someone could pay me money and essentially shred my reputation for the rest of my career, because that's what this is. Make no mistake, this is essentially extortion by Aperture, who must have came to conclude that there was no evidence. And so if you want me to get up on that stand and make a f***ing fool out of myself, like I'm going to have to in order to defend this obscene moron's theory, you got to pay up, buddy, because who knows when the next time anyone's ever going to come knocking on my door again will be. But let me be clear. You are not watching this for us to talk about Key Cycles and Trooper Paul, only so it's very clear that this is the man who found, discovered, and began the whole notion that there was a backing event that Karen Read was responsible for, so that you could see how utterly absurd the basis for Aperture's reports really was. And of course, there's more, because you might remember this whole exchange with Judge Beverly, the so-called Judge Beverly Canoni in this case, who went to great lengths to make sure the jury never heard about Trooper Paul and his Key Cycle mishap. However, this theory of his was allowed to stand and put forth by the $650,000 accident reconstructionist company, Aperture. Okay. Now, you might note that I'm allowing this exchange between Bob Alessi and Judson Welcher play out for a little while. And I'm doing that because I want you to see Judson Welcher's performance. Because make no mistake about it, the $650,000 price tag was really so that he would put on this very performance that you are seeing right now in front of the jury.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, Event Data Recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
The text stream data indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In order to properly determine the location and the timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay. So in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text stream with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So, again, the text stream event tells you the trip and it tells you the time. If you're saying associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Let me try it a different way. Your analysis, or anyone's analysis, in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No. Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon me?
What slide number?
I've got slide 9. Mr. Wolk, yes, I've got the correct one. Thank you, Your Honor. So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You reviewed you viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167?
Correct.
And in this screenshot, we can see 4 text stream events.
Actually, can you zoom in on the key cycle?
Oh, sure.
Because I think when I got to, no, scroll. So when I got to it, you can see it was that key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So to answer your question, I got it at 1264.
So if we can go back so we can see the 4 text stream events, I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that...
Are you saying there's no basis for the question?
Yes,
All right, I'm going to allow the question and I'll hear it.
You are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department. Okay.
So the objection is sustained. You need a foundation, Mr. Leslie.
Sir, as part of your work and your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with the Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right, and did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess' analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV, had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were 2 reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents review. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir, that there were do you recall that there was a report of Trooper Paul?
Yes.
Okay, and you read that report, I assume, sir?
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No. I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmation of bias.
But you did read Trooper Paul's report,
Of
correct?
course.
So, you therefore are aware that the Commonwealth has maintained up into your engagement.
I'm going to see a sidebar on this.
Man, isn't that a sidebar that we would all love to hear? The most important thing for this conversation is understanding that once Judson Welcher gets on the stand, he tries to claim that he had no knowledge. He didn't use Joseph Paul's reports to make his determinations, that they came up with this theory about the backing event entirely on their own. The only problem with this, though, is that we now have the receipts. And on these receipts, we see beyond a shadow of a doubt the very first thing, and I mean the very first thing that these guys do is examine carefully Trooper Joseph Paul's reports. Oh, don't we wish the defense team had had these receipts in time for the trial. And what a surprise that they didn't. Geez, is this a discovery violation? Now, there is one more thing that I forgot to highlight. As part of their efforts to try to find evidence on Karen Read, Aperture insisted on having all of the evidence. That would include the testimony of Nicole Albert and Tristan Morris and Caitlin Albert and Brian Albert Jr. and Julie Nagel and Sarah Levinson. Now, to just highlight how absolutely bizarre this is, imagine one of these two guys are spending hours examining testimony of Sarah Levinson and Brian Albert Jr. in order to determine whether an accident occurred in front of 34 Fairview on the night in question.
The debris that comes off of the taillight, the fragments, what speed would they be going at the point of impact when they crack and are released from the taillight?
At the impact speed or less.
In order to penetrate the sweatshirt and cut the arm across, would the shards have to be going faster or slower than the arm?
They would have to be going faster. If they're moving at a common velocity with the arm relative to it, they would somehow have to accelerate with more speed to catch up and go beyond the arm, essentially.
Is that physically possible?
No.
You can see here again also the light and the fragments are being propelled forward. So you also have to consider where Mr. O'Keefe was found. He was found in the yard about 10 or 20 feet from the road. There was no exact measurements. But if you look at the motion of the taillight, it's going forward. Now, if Mr. O'Keefe has to move diagonally to the top left of that corner, and if he's not hit with the center of mass, he can't get to where he ends up before the taillight fragments have already gone forward and been deposited on the ground. Average running speed is like 4 to 6 miles an hour. Even if this SUV is going 10 miles an hour, it shatters, the lights fracture, they're dispersed on the ground, and then Mr. O'Keefe somehow ends up to his point of rest. But you wouldn't find the fragments on him because they've already been pushed forward, come to rest, before he even has a chance to get to where they find him.
I mean, they dug through the testimony the way that we do, trying to find some way to indict Karen Read of the murder of John O'Keefe. And in the end, they determine for $650,000. Oh, yeah, right. By the way, I forgot to mention that in April, Judson Welcher signs a new contract. And this one's for a little bit more than the first one. From Judson Welcher's own admission, there's a very clear reason why he doesn't, in the end, decide to do the kind of testing that we saw with ARCA. You know, the kind with like crash test dummies or like force and physics to prove that an accident happened in this case.
Let me ask you this. Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with a Lexus at 20 miles an hour.
You could have done other tests where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct? You could have done that.
If you used the right crash test dummy, and then to set up the test, because generally you only get 1 or 2 shots at it because you damage the car, you have to know everything about the parameters. And so, again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
I guess just in case you happen to miss the blue paint tests, I'll revisit them.
And then in the lower right photograph, what I've done is I've rolled up my sleeve, taken the sweatshirt off, and I'm going to look at how this contact pattern lines up. Me just walking backwards, or actually sideways, into the Lexus. What I've done is I've painted the Lexus right rear tail light with what's called grease paint. Kind of sort of like paint, but it doesn't dry. And then I have backed up sideways, side shuffled into the Lexus with my arm out to see what the damage pattern looks like. Throw this from 2 different angles. That's me showing I'm doing test 2. This is from a camera that we have pointing down at it. This is the speed.
Did you conduct that test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus tail light on that arm?
So generally, I wanted to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
Your assumption, as I understand it, is that the Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis, sir?
No. There is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
She then put the Lexus into reverse, put her foot on the gas pedal, and began to press, not 25%, not 50%, up to 75% acceleration. There was a light dusting of snow. The Lexus tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull.
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough information to determine that.
When you're engaging in these demonstrations, are you attempting to try to show exactly how Mr. O'Keefe was struck?
No.
When you were asked to engage in the study, were you ever asked to reach a certain conclusion?
Never.
Was there ever any influence other than the data and facts on your analysis?
There's never been any influence. The influence, again, it's whatever the data shows.
When you engaged in whatever studies you undertook that you'll explain to the jury, were you given any direction or limitations on what you could or should do?
No.
When you received the information, did you understand, regardless of the result, it would be provided to everybody?
I guess, generally, yes. I mean, I go through the data, I give you the results, you do with them whatever you see fit.
Okay. And in this case, when you decided to
And while all of us were scratching our heads at this blue paint situation, why it was that he was dressed up like John O'Keefe and throwing himself into a car that looked like Karen Reed's, the reason was very simple. It was all he had to plant a seed of possibility, because in the end, Judson Welcher concedes that there is no evidence. No evidence. No evidence. So these guys are forced to take Joseph Paul's ridiculous theory and try to use some way to make it make sense, to make it a legitimate theory. And that's what they set out to do. So they bring in, almost as unbelievably as Joseph Paul, Shannon Burgess.
If I did the math correctly, sir, you've been pursuing a Bachelor of Science degree for 17 years, correct?
That is correct.
And you have not obtained it as you sit here today.
That is correct.
And yet there are the various documents that we've seen that state that you have obtained the Bachelor of Science, correct?
Again, with errors or misinterpretation.
And of course, as soon as the defense gets hold of him, we realize we probably shouldn't give him and his testimony much weight. But let's put that aside, and we'll just pretend, because we're thinking like the O'Keefe family in this case, and we're trying to give these people the benefit of the doubt. We'll just pretend that the key cycles are not a problem and that Shannon Burgess is credible, or even a little bit credible. He's tasked with trying to place Karen Reed's vehicle in front of 34 Fairview at the time and place in question. And he's tasked with trying to make this backing event work, trying to prove that it happens and is responsible for the death of John O'Keefe. The only problem, and it's like a small detail, is that in order to do that or even get close to that, number one, they have to pad the numbers.
If a trigger event is one point in time, one snap in time, would it be accurate to say that the trigger event itself lasted 5 seconds and ended 5 seconds later?
It wouldn't be accurate to say the trigger lasted that long.
That's my question.
The event lasts that long, but the trigger is only one point within the event.
The recording lasts that long.
Right.
Correct?
Correct.
So in other words, it captures, or does it? Let me ask you this. Does it capture 5 seconds before and 5 seconds after? But the trigger event is the singular point right in the middle.
That's correct.
Okay.
Customarily, when we're doing any analysis, we're referencing everything off of the trigger. That's the normal way. Everything in the Aperture reports was referenced off of the end of the event. So
Of the recording event.
Of the recording event.
Not the trigger.
Correct. And I didn't correct that. I just went with that convention for all of the analysis I did. Everything in the Aperture reports was referenced off of the end of the event. So
Of the recording event.
Of the recording event.
Not the trigger.
Correct. Everything on the left-hand side of the slide comes from Mr. Burgess's report.
So the 3 second delay was noted in his report.
It was noted.
Did he apply the 3 seconds in his analysis?
He did not.
Did he indicate in his report why he ignored that 3 second delay?
He did not.
When you do apply the 3 second correction, what do you come up with?
Now we're going to look on the subsequent slides here at all of the different ways the Aperture reports compared the vehicle to Mr. O'Keefe's phone.
To us, the prosecution put on a good case, and to us, that data from her car and from Johnny's cell phone told the whole story.
In Mr. Burgess's original report on differentiating, the January report, which did he use to determine his determination of the clock skew?
In his initial January report, he never actually takes the calculation to the end by applying the differences in times to the calculated time for 1162-2, but he does do the math, which I'll show, for the differences on these phone calls. On the left is an excerpt of page 33 from Mr. Burgess's initial report. And what he shows here is he has identified 7 call logs that exist both in the infotainment from Ms. Reed's Lexus and in Mr. O'Keefe's phone. He puts them in a table form. Then he actually goes on and calculates the difference between those 2 times. So that's what I meant by he sort of does the math. He makes my job a little easier, and the numbers are already there. He just never applies these to any of the times. So that's where I step in and say, if I take that 3rd column that he lays out, those are in seconds. If I apply those seconds, that adjustment to 12:31:43, where do we end up with John's interaction window in those times?
The first report that they put forth was void of the knowledge of 2 of the key Commonwealth witnesses in their case in chief.
Yes, around 12:31, 56 or 57 is the start of the health event, 36 steps.
The only way he could get this kind of an injury was to fall backwards, hit the back of his head, and then the resulting, energy forces going into his brain, into his base of his skull. His injuries were very substantial, and it's more probable than not that at some point he quickly became unconscious and was unable to do functional activities.
And of course, the defense expert, Dr. Elizabeth La Posada, one of the most brilliant women in the whole world, confirms that there was a coup contra coup injury and that John O'Keefe would have been dead almost immediately within 10 minutes or so from having a crushed skull. So what this meant was that John O'Keefe, after he fell, would have been incapacitated, would not have been able to be up and walking around or using his cell phone because his fine motor skills would have been rendered impossible.
What did you conclude in terms of finishing the work? Sure, I did all of them. And so I highlight on this particular slide, I just highlighted the very first one he has in here. In that case, he identified that Mr. O'Keefe's phone was 2 seconds slow relative to the infotainment system. So if we apply only that adjustment, then John's interaction window becomes positive 28 seconds.
Did Mr. Burgess apply all of the potential offsets?
He didn't apply any of the offsets. He calculated all of them, but he didn't apply any of them. Regardless of which offset you apply, John's interaction window remains positive. The number changes, but it remains positive.
And the problem that Burgess and Welcher now have is that every single time that Shannon Burgess puts forth for the time of this backing event happens before John O'Keefe stops walking around and using his phone. And that's even with padding the numbers. So no matter what they do, and including fudging the numbers to try to push them back so that they get closer to Ian Whiffin's time, they still can't get it right. And so Ian Whiffin testifies on April 28th. And on April 29th, thanks to the note-taking and invoices of Aperture, we see that Shannon Burgess bills for 8 hours to create a supplemental report. And though he tries to claim on the stand that nothing really changed, as it turns out, he changed everything.
The trial starts April 22nd, correct?
Correct. Generally.
No, the trial in this case, this trial, about April 22nd. After the trial starts and after witnesses, of course, are appearing, you prepare another report, correct?
Correct.
And that's your May 8th report.
Correct.
Right in the middle of this trial.
Correct.
May 8th, keep that in mind, okay? May 8th report.
Correct.
And right in the middle of this trial, you enlarge the number for the 21 to 29 range. That's bigger than what was in your first report, correct?
No, that is not correct.
Well, you changed the number, don't you?
No, I did not change the number.
This wasn't done on your initiative. You put in writing you did it at the request of Mr. Brennan. Which is it?
So that was on my own initiative. This is a holdover, so a copy and paste from my original report.
All right, so I skipped over a little bit here so that we wouldn't be here all day. What they're talking about here is why did Burgess all of a sudden in the middle of the trial decide to update, quote unquote, or change his report? And in the report itself, it says in the opening paragraph a sentence about, in response to your request, Brennan, this is the report. Okay, so that's what they're talking about here. They're talking about the updated, amended report, the one that he submits on May 8th, and why it is that he submitted that report. Why all of a sudden, out of nowhere, did you just decide to amend the report? Did Hank Brennan tell you to do that?
You're explaining the May 8th report in your language pursuant to your request as a cut and paste from a previous report?
Yes, I am.
You didn't review it this time, though, did you, sir?
No, I did not think it was significant.
Oh, you don't think it's significant, sir, that the matter is in the middle of a trial and there's a request for a new report after testimony has occurred in that trial? You don't think that's important? Objection. Sustained. Why did you prepare the new report then?
Sure. So there was a claim from a PowerPoint presentation by Mr. DeSilgra of trying to adjust clock syncs or making clock adjustments based on the synchronization of certain events. That was produced in March. Upon reviewing that, my initial thoughts were to address that in testimony. But as I was preparing for trial, I made the decision that it needed to be better addressed in a supplemental report.
All right. So thanks to the Aperture receipts, we know this is an outright lie, a bold-faced outright lie by Shannon Burgess. So on April 25th of 2025, Welcher, Brennan, and Burgess all meet to have a discussion, okay? The day after Ian Whiffen testifies, the day after he testifies with the timeline, right? The timeline that states when all of the human interaction with John O'Keefe's cell phone stops at like 12:32 and 20 seconds, something like that. The day after, Shannon Burgess spends 8 hours updating his supplemental report. 4:29:25, digital forensics, time spent writing supplemental report and trial presentation. Okay? But hold on, there's more. May 7th, he spends 5 hours reviewing the supplemental report, and then on May 7th, meeting with attorney and Judd Welcher. Now, it doesn't say who that attorney is. Is that attorney Hank Brennan? Or is that their legal team? Somebody for them? But note, it's pretty interesting that every other time when they meet with Brennan, it's written. His name is in there, except for this one on May 7th. Very interesting.
So do you know the date of Mr. DeSoto's report as March 5th? Does that sound right to you?
Yes, that's what I said.
Remember, this is a bold-faced lie, and we now have actual documented evidence. This guy is perjuring himself. And I guess, you know, it's sad. This is kind of sad, but I guess it's kind of true. It's like if this guy was willing to put himself out there and actually testify in court, lying about his academic background, I guess once a liar, always a liar. And that's a terrible thing to say. I don't want to, you know, make that kind of a general statement. But I mean, maybe that's just the way it is. At least that's the way it is here with Burgess.
So you had Mr. DeSoto's report that you claimed was the basis for you on your own in the middle of this trial, creating and submitting a new report. You claimed that the basis for that was Mr. DeSoto's report of March 5th of 2025.
That is correct.
You waited?
It's a total lie. This is a total lie.
2 months?
Again, my initial thoughts were to address it on testimony.
Did you wait 2 months?
Just let him finish the answer.
Here's my question, sir. Finish it how you are.
Sure. So
2 months, was it 2 months between March 5th and when you submitted your report on May 8th? Was that 2 months?
yes, it is.
And now Aperture puts forth somehow a range of times, again with padded numbers, to try to get closer to Ian Whiffin's time that John O'Keefe stops using his phone. And even in that case, they produce 9 numbers, and only 2 of those numbers wind up fitting their theory of the case. And in the end, Judson Welcher is paid $650,000 to be an obstructionist, to do everything he can using smoke and mirrors to hide the very painful reality that they have absolutely no evidence that there was a backing event, that John O'Keefe's injuries came from a car accident, or that these times even add up. And despite what is a noble effort on the part of Aperture to look over every single bit of evidence in this case, in the end, what we are left with is data that ultimately proves John O'Keefe was up and walking around after the proposed backing event, and that Judson Welcher knows how to dress up like John O'Keefe and put paint on a car that looks like Karen Reed's. There's even an argument to be made here that Judson Welcher and Shannon Burgess did more to bolster the defense's case than they did the Commonwealth's.
Of note in this angle of the paint transfer test.
I did. I slowed this video down, and so as you can see, as it starts out, and you'll see the vehicle starts to slowly back. So there was no photographs showing the position of the arm in the back of the car. The video is from the side, and the top video, you can't tell where the arm is positioned on against the tailgate. But whatever position it's at, you can see as the car backs up here, look at the elbow and the upper arm. If the car backed directly in this direction, there would be no contact with that elbow or the upper arm. And remember, this test is to show where the paint would transfer and if that correlates to the lacerations.
You mean, before you start the video, when you say there would be no contact with the elbow or the upper arm, you mean the biceps area and from the elbow up?
That's correct.
Is that based on the photograph on the right and the positioning of the surrogate?
Exactly. You can see right now, if the car just backed directly straight back, it would not contact the elbow or the upper arm.
Before you play the video, what did you note when the car from the angle to the right of the video on the right? What did you note as the car, just before the car starts to make contact with the surrogate? What did you note?
So in order to get that pattern on the arm, right as the car contacts the arm, the surrogate pushes his elbow forward, leans into the car against the light, and then rolls off.
Can you play that for us, please? Did you see what you were describing in that video?
I did, and I can slow it down. So you can see, even at this point,
as the car approaches, it would not contact the elbow or the biceps. So as it comes in, watch the elbow. All of a sudden, shoot in. Surrogate turns his arm in and then leans against the light cover. So this is not indicative of someone standing there and having a car back into their arm. In order to get that pattern of pain on the arm, someone would have to stand there, and as the car approached and contacted their arm, they would have to actually push their arm forward and lean into it to get that pain pattern.
Is that, in your view, proper scientific testing?
Sustained. And it seems like Hank Brennan was a little confused about what his job was here. If he had been playing the role of the defense attorney in this case, trying to plant a doubt or put forth that maybe in some world it could be possible that this was from a car accident, not a dog, and that possibly this backing event could have been Karen Reed because we don't know that these key cycles weren't just a misfire. Okay. Even though the defense witnesses pretty much shut that down completely based on the laws of physics, he fails to remember that in this case, there's that whole pesky beyond a reasonable doubt thing, and that no, you are not playing the role of defense attorney, you are playing the role of the prosecution. And so, of course, this is the very best that the Commonwealth of Massachusetts, to the tune of over $1.4 million, was able to put forth as evidence that Karen Reed commit this crime. And so what does that really say in the end? Well, first it says that they knew that they didn't have any actual evidence to indict Karen Reed. But it also says something much more important that is pretty easy to overlook. And that is, many of us have been asking, why is the prosecutor's office doubling down at every turn? Why won't they let this go, just cut their losses and run? And there is an answer to that question. And it's very obvious. And the answer is this whole pesky thing that they did egregiously early on in this case, the planting of the taillight. The reason why the prosecutor's office cannot let go of Karen Reed is because in so doing, what they are admitting is that their guys, Massachusetts state police officers in their office, in the DA's office, okay, the homicide investigators that work directly for Michael Morrissey, planted taillight evidence in this case. How do we know? Because if there is no car accident, which there wasn't, if that backing event does not belong to Karen Reed, which it definitively doesn't, then that taillight is put there by somebody else. And guess who that would have to have been? Because there's only one group that it could be. The same group that deleted videos in this case, hid evidence, inverted videos, edited taillight videos. The same group that 100% by the end of the first day had decided that serious charges were going to be brought against Karen Reed and there were not going to be any other suspects. The same group who wrote out suspects, just wrote them out of the house and completely until they were called out on it by Karen Reed's unbelievable defense team. The same group who proved over and over and over again that they should never, ever have been given a gun and a badge. Not by anyone, not anywhere, not at any place, and not at any time. So this, make no mistake, has always been about self-preservation. And let this be a warning to all of us. This is the power of a corrupt prosecutor's office and the lengths that they will go to try to convict an innocent woman if it means that they themselves will be indicted of a crime instead. Because that is the situation that these people found themselves in that morning. Not to mention that what they were really doing was protecting their own, protecting Brian Higgins, the ATF agent, and the disgraceful Brian Albert, a longstanding Boston police officer who had a long history of drunken brawling, actually beating up other police officers under the influence, who had essentially a wild animal for a pet that had escaped the yard and injured innocent pedestrians in front of the house before, who was so scary that guests were not allowed to interface with the dog. And the saddest thing about this case, the saddest thing, is that John O'Keefe was a good man, a real police officer, a legit police officer, someone who took an oath and kept it. And unfortunately, these piece of garbage buffoons are so much more interested in protecting themselves than they are of actually seeing justice for the real killers in this case. Now, there is one more detail that I almost forgot to mention. As it turns out, Judson Welcher charged the Commonwealth for the time that he took to fly from California back to Massachusetts. Apparently, he was ostensibly in the building, ready to refute ARCA, to be called back up, as you might remember, after the ARCA witnesses. And then there was this whole incident about x-rays.
Proof. And so proof is somebody looked at it, somebody took an x-ray. I haven't seen any evidence of an x-ray of the arms.
God save the Commonwealth of Massachusetts.
I live inside my own world of make-believe. Kids screaming in the cradles, profanities. I see the world through ice covered in ink and bleach. Cross out the ones who heard my cries and watched me weep. I love everything.